First, thank you. Should the DA have charged Matt Alder with manslaughter in the shooting death at the No Kings protest?
No, absolutely not. This is a case, it's an unfortunate tragedy, but it's one involving self-defense. The prosecution themselves understand and have recognized that self-defense is involved in this case. Self-defense and defense of others. You could act if you're trying to prevent other people from being injured, so you're defending yourself and third persons. So this case should never have been filed.
There seemed to be, with the DA's presentation, an analysis of, well, the first two shots were okay, but the third shot was reckless. Do you see a problem with that contention?
Yes. So you have several different legal theories. You have one, it's called transferred intent. So what I intend to do to the person who is the target, if I miss, my intent is transferred to the bystander. So there's a legal concept of transferred intent. So if it's permissible for me to shoot at my target and I miss, then it's permissible for me to miss and hit my target. So it's transferred intent. So the prosecution theory recognizes there is some transferred intent, and it's not murder, but the activity was reckless. So they have a theory that the transferred intent wasn't a complete defense. So self-defense was not complete because it was reckless.
So I have two things at work here, right? Self-defense or defense of others,
yes.
That's one. Transferred intent, that's two. Do you see problems with this prosecution because of those issues?
Right. Their theory is it was excessive. That if you show up to a knife fight with a gun, that might be excessive, right? It's not equal. If it's just a fight, people are fighting it out, and you bring a gun, that's a problem. And that's what happened in the Massachusetts case, that the person used
This is the case that Sim Gill
that he's relying,
referenced.
That he's relying on, is that someone brought a gun to a fist fight, that no other witnesses in the Massachusetts case say that that person had a gun. So he's relying on a case that's not necessarily the equivalent. So that Massachusetts case involved excessive self-defense, that you brought a gun to a knife fight or a fist fight. And so in this particular case, the target had a weapon and was manipulating that weapon, and in fact was shot, but no charges related to that portion of it. It's only the missed shot that hit the bystander. So they're saying that you were reckless, you should have been a better shot.
Had he hit Gamboa again with the shot, under this analysis, it would have been okay?
No charges, based upon their analysis. So we don't know how close the bullet was off. It could have been off 2 inches. We don't really know the trajectory of that. And that's why the analysis from the prosecution was focused on potential ricochet, doing an analysis on the bullet, saying it was a clean shot, that it didn't ricochet off of anything or go through any other objects or persons.
So bottom line this, problems that you see with this prosecution.
Right. Absolutely. There are problems with the prosecution, is that if you rely on their own theories, the prosecution theory, they recognize self-defense because they haven't charged murder and they haven't charged Gamboa, the shooting of Gamboa. So they recognize within their own documents and within their own charging documents that self-defense exists. They're saying it's excessive, but it is not excessive because the other party had a gun. The other party had a gun, and the peacekeeper or safety person had a weapon as well. And so they were simply off target. It was an accident, it was a mistake, but they are allowed to do that based upon the prosecution's theory because of self-defense and transferred intent, where you intend to, if you have self-defense, that permission transfers to the bystander. So that legal theory of self-defense or defense of other people transfers to your shot on the bystander.
Any way you think Alder is found guilty?
A jury can make a mistake. A jury, just like the prosecution has made a mistake in this case, a jury can make a mistake and he can be convicted if they are confused.
You suspect that would happen? That will happen?
Because it's a tragedy. Someone has died, and so doing nothing doesn't feel satisfying. That emotions are high, and you do want something to happen.
You want some resolution.
You want some resolution.
Some sense of justice.
Right, some sense of justice. Someone convicted of this. But the truth is that self-defense applies, transferred intent applies, and if you apply those legal theories correctly, you end in a result where the person has a not guilty verdict or they're not charged. The likely outcome is a not guilty verdict, and so the prosecution says, oh, well, the jury has spoken, there's a not guilty verdict, and they're off the hook. They're no longer responsible for not charging that person. So they're bringing a case that, in my opinion, they're unlikely to succeed in, but politically that's more popular than making the hard decision and saying, no, sorry, there's just nothing we can do here, that we should just recognize that it's a self-defense, defensive third-person case, and then unfortunately we can't charge.
Do you think they brought the charges because of political reasons primarily?
And sympathy, and which is understandable. I mean, it's tough. Someone has a valuable member of society is no longer with us. All life is precious, and it's tragedy. But we are trying to protect other people. So they thought there was a perceived threat. The person was manipulating a weapon in a large crowd. You could have many people injured in that situation, so that person reacted. And the prosecution has recognized that reaction was correct, that there are no charges against shooting of Gamboa.
You have represented a defendant in a case that is at least somewhat analogous to this.
Yes.
What were the circumstances there?
Yes. So in the Clara case that went all the way to John Michael Clara, went to the Utah Supreme Court. And in that case, they said that his firing of his weapon was justified. So what happened was a stolen snowplow truck rammed into his vehicle, spun him around, and he got out of his vehicle and shot at the oncoming truck, hit that vehicle, and then actually missed and shot a bystander's vehicle and broke the window out of that vehicle. So in that particular situation, the Supreme Court said he was justified because he was perceiving a threat, that the vehicle was coming once again at him and at his passenger. So he defended himself and he defended his passenger from an attack by discharging a firearm.
His bullets never hit a person.
Right.
And hit a vehicle but did not hit a person.
Right.
So had they hit a person, would the outcome have been different?
We think that, based on the Supreme Court ruling, that he would have been justified if he did, in fact, hit a person. Fortunately, no one was injured, but we believe that it would be justified.
So in that situation, there is something called a justification hearing.
Yes.
You requested one. What is a justification hearing, and why did you want this for your client?
Yes. So a justification hearing is available if you believe that there's self-defense or defense of third person. So you, as a defendant, testify or present evidence, which is a little unusual because you have the Fifth Amendment right to remain silent. So you actually have the burden of then showing that it's self-defense. You could do that at trial, but you can also do it at a justification hearing and establish that there's self-defense or defense of third person.
You're going on offense at this justification hearing.
Yes.
And the justification hearing is where the case was originally dismissed, Michael Clara's case. And then there was an appeal, and eventually the Supreme Court made its decision. So if you were representing Matt Alder, would you be requesting a justification?
Yes. So
hearing?
After the preliminary hearing, you would request a justification hearing. And in this particular situation, the judge may make a determination that justification was exists, but self-defense and defense of third person is still available at trial if the judge doesn't dismiss the case at the justification hearing. So that defense is available at the justification hearing and it's available at trial.
Yeah, how do you think the defense team is going to play this?
I think that they will use self-defense and they will request a justification hearing, but that's months out.
Okay, this is going to take a long time.
Yes.
For people who might say, okay, you're a defense lawyer, you don't like what the prosecutor does most of the time. Your job is to defend clients who've been charged by the DA's office. And okay, so you would naturally speak against a prosecution, a high-profile prosecution, perhaps. How would you respond to those feelings, those sentiments?
Well, really, the analysis of self-defense is what we all understand is a threat, right? So we all intuitively know about self-defense or your defense of third person. I can defend my house. I can defend my kids, my wife from an attack, or just the general public. So if somebody is going to, you believe, unload a firearm on a crowd, you can step in. And we understand that. We understand self-defense from growing up in fights in the schoolyard or whatever, that it has to be proportionate. So if we're fighting with fists, then I have permission to fight with a fist. If you bring out a knife, then maybe I have permission to bring out a knife. If you bring out a gun, well then I can respond with a gun. So it has to be proportionate. And we all understand what self-defense is, how we defend our family, defend fellow citizens. And so if you look at this, the defendant, Alder, used a gun when he perceived a threat from a gun. And the prosecution agrees with that because they haven't charged with shooting Gamboa. So their analysis is internally inconsistent, that they're not remaining consistent. They're saying it's self-defense in this particular case, but with the bystander it's not. And because of the legal concept of transferred intent, they're not consistent, and that's the real problem in this case.
You think the prosecution has painted itself into a corner?
That
that's the way it sounds.
Right. When you present that, it makes some sense, but when you break it down and analyze it step by step by step, it's inconsistent and mutually exclusive, and it doesn't work.